Uh, Nitin, have you sent her the email? Send her an email?
I have already sent her an email.
Okay, then we can start. Huh?
I have said, please join. I have again sent her the link separately, only link, nothing else.
Okay, thank you. Thank you. Right. So let us start. Huh? It is my pleasure and privilege to welcome all of you to this roundtable on judiciary, its independence and integrity. On behalf of Justice K.T. Desai Memorial Committee, I feel honored to have such a distinguished panel with us to discuss a subject of vital importance to all democracies, especially democracies which have especially democracies which have constitutions that provide for division of power between different organs of governance or provide a system of checks and balances to ensure good governance along with respect for individual freedoms and human rights. Judiciary has a constitutional role to play in this system. It is entrusted with the task of maintaining the constitutional balance in exercise of power by different organs of governance. And to discharge this role properly, it is essential that judiciary is independent. Judges do not owe allegiance to any political party and can decide matters with an open mind on the basis of the Constitution and the laws. Integrity is the unspoken first premise for any appointment of a judge. At times when an individual may have to challenge the action of the government, it is important that the matter is decided in court on its merit without judges being pressurized in any way. The question before us is, how do we ensure that the judiciary has the necessary independence and integrity? Are the existing systems in some of the countries, especially those which believe in the rule of law, adequate? Is it possible to remove unsuitable judges without undermining judicial independence? What other safeguards are required? These are some of the issues before us. The easiest way to destroy an institution is to appoint wrong people to it. I hope this panel will bring their international experience to bear on the question of independence and integrity of the judiciary. If I may add, this is a subject which had deeply disturbed my father, Justice K.T. Desai, during emergency. He expired before the emergency was lifted. And he would have been very happy to note that we were met today to discuss the subject. Since 2005, my sister, Dr. Sadhna Desai, and I have sponsored, and Justice K.T. Desai Memorial Committee has held a lecture every year in the memory of Justice K.T. Desai. This is the first time that we are having a round table. We miss the magnificence of the central courtroom of the Bombay High Court, but WebEx at least makes it possible for us to meet. We have a very distinguished panel of judges and jurists who are experts in their field to share their experiences and their views with us. I hope Lady Justice Martha Koome is here. She is the first Lady Chief Justice of Kenya, and she's been recently appointed. I welcome her to perhaps her first international participation. Our congratulations and best wishes to you, Chief Justice, for a very successful tenure. Lady Arden, Judge of the Supreme Court of United Kingdom, is an outstanding judge with a brilliant academic record and an outstanding record as a judge. Before her appointment to the Supreme Court, in addition to her judicial duties, she has been a member of the panel of UK ad hoc judges of the European Court of Human Rights. She has been chair of the Judges' Council on Constitutional Reform and Chairman of the Law Commission of England and Wales. We are delighted to have her with us. Justice Albie Sachs is famous. He is a former judge appointed by Nelson Mandela on the first Constitutional Court of South Africa. After being twice detained in South Africa for his anti-apartheid activities, he had to live in Mozambique when he was blown up by a bomb planted in his car. He lost his right arm and one eye. After the apartheid was abolished, he helped write the Constitution of South Africa and served for 15 years with great distinction on its Constitutional Court. We are extremely happy to have him with us today, and we hope to benefit from his extensive experience in this difficult field. Our own Justice B.N. Srikrishna needs no introduction. He is much more than a former judge of the Supreme Court of India. He is famous for the Srikrishna Commission of Inquiry into Bombay riots. After retirement, he was appointed to chair the Financial Sector Legislative Reforms Commission, and he chaired the committees to study issues related to data protection, very much in the news at the moment. Its report and draft bill are before government. He has also lent his services to various charities and public institutions. We warmly welcome Justice Srikrishna to this roundtable. Justice Isaac Lenaola of the Supreme Court of Kenya has sent his regrets for not being able to participate on account of the demise of a close friend, and he is required to attend his last rites. Our sympathies. Mr. Jan Smit is the Senior Research Fellow and Acting Deputy Director of Bingham Center for the Rule of Law, part of the British Institution for International and Comparative Law in London. His work has focused on the use of legal framework to foster and protect the independence of the judiciary. And if I may say so, he is the right person to guide us on the proper framework for ensuring this independence. Amongst his books is a book dealing with appointment, tenure, and removal of judges under Commonwealth principles, a compendium on analysis of best practices. Thank you, Dr. Smith, for lending your expertise to this roundtable. Mr. Arvind is the Senior Advocate of the Supreme Court of India. He is a leading authority on constitutional law and taxation. His book on constitutional law is probably in the office of every Indian lawyer. He was a leading counsel in the National Judicial Commission case and has made a close study of cases in India and elsewhere relating to interaction between the executive and the judiciary. Thank you, Mr. Datar, for joining this roundtable. Last but not the least, let me introduce to you Mr. Sharad, Senior Advocate of Kenya. He was the chairman of Judges and Magistrates Vetting Board of Kenya, which was entrusted with the difficult and delicate task of vetting judges and removing unsuitable judges from the judiciary in accordance with the provisions in the new Constitution of Kenya, but without undermining public confidence in the independence of the judiciary. Justice Albie Sachs was also a part of this vetting board. They carried out this task with great distinction. Last year, we heard him on the subject, which aroused a lot of interest as well as discussion, which has in a way led to today's roundtable to discuss various aspects of this subject. He has been honored with the colorful and prestigious title of EBS, Elder of the Burning Spear. Justice Deepankar Datta, Chief Justice of Bombay High Court, just joined us for a few minutes. He is traveling and therefore he is unable to participate. I hope this roundtable will discuss how appropriate persons can be appointed as judges in the first place so that we do not have to reach the stage of having to remove them. Secondly, which are the other preconditions of judicial independence, such as service conditions regarding retirement benefits, which will ensure independence and non-dependence of judges on any authority for necessities. And of course, we need to consider removal, whether it can be done without undermining judicial independence. I call upon Mr. Sharad Rao to open the discussion, to be followed by Justice B.N. Srikrishna and others as I call out their names. After each of the speakers have expressed their view, there will be a discussion within the panel on various issues which have arisen. We will try to reach some conclusions on the systems that can respect independence and integrity of judges. Let us hope. And questions and comments from the audience can also be recorded in chat section, or they can be sent to Mr. Vishal Kanade, Secretary of the Bar Association, at kanade.vishal@gmail.com. After the speeches, there will be a vote of thanks by Mr. Nitin Thakkar, President of the Bombay Bar Association. So I now call upon Mr. Sharad Rao, Senior Advocate of Kenya, to open.
Thank you. Thank you, Sujata. Good afternoon and welcome to all the co-panelists. Justice Manohar has asked me to just brief you very briefly on the subject on which I spoke at the last Katie Desai Memorial Lecture. The subject of my lecture there was vetting of judges and magistrates in Kenya as a unique experiment. As Justice Sujata Manohar said in her introductory note to the panelists, Kenya's new constitution prescribed a vetting process applicable to all judges and magistrates who were in office on the date our new constitution came into effect. The effective date of our new constitution was the 27th of August, 2010. In complying with the constitutional requirement, Kenya's parliament enacted the Vetting of Judges and Magistrates Act 2011, which came into force on the 22nd of March 2011. The vetting board appointed under it consisted of 9 members and included 3 eminent judges from the Commonwealth. Those invited included, as you just heard from Sujata, Justice Albie Sachs from South Africa, a world-renowned jurist, and we also had the privilege of having the then current Chief Justice of Ghana, Georgina Wood. Justice Sujata Manohar was also invited to join the board, but she was not able to join us because of prior commitments. I was appointed by the then president, who in consultation with the then Prime Minister appointed me as chairman of the board. The transitional and consequential provisions of the Constitution stipulated that where the board found a judge unsuitable to continue serving in the judiciary, it would, within 30 days of the determination, inform the concerned judge or magistrate of the determination in writing, specifying the reasons for the determination. And once informed of the decision, the judge or magistrate was deemed to have been removed from service. A judge or magistrate who was dissatisfied with that determination could request for a review by a different panel within 7 days. However, the board would not grant a request for review unless it was based on the discovery of new and important matter which was not within the knowledge of the judge or magistrate at the time of determination, or some mistake or error apparent on the face of the record. The transitional provision stipulated that a removal or a process leading to the removal of a judge from office by virtue of the operation of legislation contemplated under the subsection, shall not be subject to or review by any court. This, as the lawyers would recognize, is an ouster clause, and some judges did not take kindly to this provision. Several cases were filed against the board, and the High Court, as well as the Court of Appeal, ruled against it. However, we decided to refer the matter to the Supreme Court of Kenya. We argued that the ouster clause was an integral part of the constitutional plan for the transition within the judiciary, and the ouster clause was necessary in our submission for 4 reasons. 1, because it was a one-off transitional process to vet a judiciary which had lost the confidence of the public. 2, it had to be swift enough to deal with a large number of serving judges and magistrates, and be brought to completion without unending litigation. 3rd, because it had to be credible in the eyes of the Kenyan public, that had to be seen as other attempts to reform the judiciary had pettered out in the courts. And 4th, because the public, having lost confidence in the serving judges, could not be entrusted a supervisory role where they would be perceived to have a conflict of interest, to review the vetting decisions that turn on the conduct, character, and professionalism of their judicial colleagues. The Supreme Court upheld our submission and dismissed all the cases that had been filed against us. The ouster clause was applied effectively in Kenya. For the Chief Justice, P.Datar, the Chief Justice of the Bombay High Court, who presided over the lecture, while stating that the finality given to the decision of the vetting board may have been necessitated by the prevailing circumstances, said that in India, there is hardly any administrative decision of a statutory body visiting a party with civil consequences that enjoys such an absolute immunity and can escape a judicial review by a constitutional court. He said that there is nothing like an unfettered discretion on the accountability of an action in a constitutional court. So this and some other remarks that I made drew a lot of comments and I may say even criticism of the comments that I had made, and that is what has led the host today to organize this particular roundtable. Thank you, Sujata.
Thank you very much, Mr. Sharad Rao. And can I now call upon Justice Srikrishna to...
Thank you, Sujata, for giving me this opportunity of interacting with such eminent judges and lawyers all over the world. Now, I actually was one of the persons who attended the lecture given by Sharad, Mr. Rao on the last occasion last year. The board, the vetting board that was conceived of in Kenya might have been justified in India if you were at a situation of tabula rasa, in the sense you had a clean slate on which you could write things. We have had a constitution right from 1950. The constitution has virtually crystallized itself into certain principles. And the constitution has granted immunity for the judiciary below the high court level. There is no difficulty because there is always a disciplinary procedure and how it can be done. For the subordinate judiciary, the high court is the disciplinary authority, and with the recommendation of the high court, the state government can act. Now, as far as the constitutional courts are concerned, I'm speaking purely from the Indian perspective. Let me be frank about it. What my experience has taught me. The judges of the High Court and the Supreme Court have been deliberately granted this kind of an excessive freedom because if you look at the constitutional debates, it was debated very much, and then it was thought that to err on the safer side was to grant total immunity and independence to the judges. Now, the remarks of the Honorable Judge of the Bombay, Chief Justice of the Bombay High Court, which Mr. Sharad Rao referred to, I remember that also. Now, this is problem. So if you have a judiciary and an executive and a legislature. And if you want each to be the check or balance against the other. Now, if you have a situation where the judiciary, the legislative and the executive, obviously they go hand in hand. They are loaded, and if nobody is there to check them, it is impossible to carry on in a democratic setup like ours, where the constitution rules the roost. Now, my own feeling in the matter is that as in the academic field, there must always be, and there should be a scope for peer review. The review has to be by the peers, in which case the question of independence is not really taken away. Now, I would suggest that instead of the present system, which has been completely gamed by the executive, as we have seen during the emergency, we have also seen it later on, and we also had some unpleasant experience even at the Supreme Court on account of some of the learned judges protesting against what was happening. And we also have this very recent experience of the Calcutta High Court, the tussle that is going on between the Chief Justice and the puny judges. Now, this is somewhat not only unpleasant, it is also embarrassing for the judiciary as a whole. And that kind of an embarrassment causes loss of independence. I would prefer that you have a setup which is governed, let's say, 1/3 by sitting judges of the highest court, 1/3 by retired judges who have no axe to grind, and 1/3 not by executives, not by politicians, but real legal scholars, whether they are from this country or abroad, professors of the universities. And if you really want some lay persons, pick some 1 or 2 and put them in the member. But the majority would be governed by the judicial minds who are the peers of any new entrant or an erring judge already on the seat. But this is subject to a healthy convention that whatever the peers say must be accepted implicitly and without debate. And it should be an honor that I am going to resign if my peers say that you are no good for this work. Now, if this convention is developed, it's fine. If you bring in a law of any kind, that is bound to conflict with these constitutional provisions. And unless the constitution itself is amended, we are going to have a serious problem. Amendment of the constitution is itself a very doubtful exercise at the moment. And I do not know how that can ever be possible. And ultimately, the constitution, this is the interesting thing. The constitution contemplated the process of removal of a judge as a pure political issue, except that there was a committee of judges to find out whether the judge was guilty or not. And on their report, there would be an impeachment process which would be moved in Parliament. And we all saw what happened in the case of Justice Ramaswamy, that it was defeated without a single vote being cast against it by merely abstention and not reaching the 2/3 mark. Now, that is our experience of what has happened under the Constitution. If we can manage to have some kind of a consensual mechanism by which it is held that if the peers say go, you must go. And for appointment, it is very easy because the peers can always look at the record of a person within or without the state and then come to a conclusion. And there would be no question of pulls and balances that has been alleged against the collegium system right now. If that can really happen, that would be an ideal situation for this country too. These are some of the thoughts that came to my mind presenting it to the panel. Thank you.
Thank you very much, Justice Srikrishna. May I now call upon Lady Arden to give us her views and her experience of how the current system in the United Kingdom is working. Lady Arden? She was here.
Must be some problem with the internet.
Oh dear.